thank everybody for coming today. My name's Charlie Sauer. I'm president of Entrepreneurs for Growth. I'm also the co-director of the Inventors project. And what we were founded to do was to bring together inventors and really work on Capitol Hill to educate everybody what the invention process is and how intellectual property works in the business world. And today, though, we're kind of here as an emergency because HR 9 is again moving quickly, the Innovation Act. And although it's called the Innovation Act, only one inventor has been called to testify in any of the hearings this year or last Congress. We find that amazing in a bill that is supposedly dealing with innovation to hold out the true innovators. When we talk about job growth, we talk about 65% of jobs are created by small businesses. That happens to be the small inventor, the guy in his garage that's 2 to 3 people, that is either 2 to 3 people this year and 500 in a year or two, or likely out of business. We have investors up here who invest in those small startups. And the bill that we're talking about today hurts this relationship every step along the line. I'm not going to talk very much. In most groups, I discuss myself or introduce myself as an inventor as well. I'm an amateur or a novice. I don't have a patent to my name. The people that we have here either have multiple businesses behind them or have multiple patents behind them. So I'm going to turn it over for quick introductions. Actually, can I start with Lewis?
My name is Lewis Foreman. I'm a serial inventor and entrepreneur. I started my first business while I was in college. I have 12 registered patents. My firm has over 700 that we've been involved in the development of. And so what we do is we create ideas. We turn ideas into products. And my staff of over 70 people are involved in the invention process. So we design and engineer consumer products and medical devices. But we don't manufacture anything. We license our intellectual property to manufacturers who are good at making things, who are good at marketing things. And so in many cases, you would say that I'm an NPE in the sense that we're a non-practicing entity. We don't make what we produce, but my employees are paid through the royalties that we generate by putting those great inventions in the hands of companies that can do something.
I'm Rich Baker from West Newbury, Massachusetts. I'm the inventor on 18 US patents. Many of them in the area of web access to factory automation equipment, Ethernet networking schemes. And a couple of years back, my son came to me and said he wanted to do a patent on a laser projector. And he and I worked on it, and we have 3 patents now that we own in the family. And in addition, I work with another independent inventor on a company that's an invention factory, and we filed 20 provisional patents last year on the Internet of Things area.
My name is Warren Tuttle. I live in Connecticut. I'm the president of the United Inventors Association. We're the largest nonprofit group dedicated to inventor education, and we have about 100 clubs around the country that we're affiliated with to help people learn about the invention process. I also had my life changed a number of years ago when I teamed up with an inventor who developed a product called Misto, the olive oil sprayer. Any of you who are cooks may know the product. We started out of a garage and have gone on to sell over 10 million Mistos. So it's I've seen the significant side of innovation in this country. I also run the Open Innovation Program for 3 large industry-leading companies, the largest housewares company in the U.S., the largest power tool company in the U.S., and a DRTV company, and I've dedicated my life to making sure that inventors are represented and they get their products to market and are successful.
I'm Paul Morinville. I've got about 30 patents and pending applications in enterprise middleware. It's real exciting stuff, but it controls what you see in your systems here and security and how data moves between systems. It's something you don't see, but I started a company based on it. My patents were massively infringed, and for 15 years I've been fighting it. I had hair when all of this started, and now I'm going door to door. Some of you folks I've met.
Matt Simchek, I'm from Los Angeles. I'm actually CEO of a startup called Zagara. We actually have patents in the augmented reality and retail space. And we have a product in market that's being used, virtual dressing room technology. And part of our concern is we've kind of dealt with both sides of the equation with patent trolls and other larger tech companies infringing our patent. So I can take questions on that later.
I'm Randy Landrino. I'm the former president of the Tampa Bay Inventors Council, current founder of Independent Inventors of America, which is a national inventors group. I'm an inventor. I have 3 patents. They're in the consumer product area. One is a type of a brush for pets, cats and dogs. And I've been here going door to door, trying to get the word out about how this bill is destructive and fatal to independent invention.
My name is Shalom Wurzberger. I am an independent inventor and a patent agent. As such, I represent more than myself. I see how things like the America Invent Act and other anti-inventors legislation in the last few years have hurt small inventors. Myself, I have currently, I can't remember how many patent applications. Right now I have 9 patent applications pending, ranging from super high efficiency solar cells, hyperspectral imaging, different type of displays, fiber communications and others. As I said, I can see how bad is the effect of the anti-innovation law by almost all of my clients are small inventors. And let's just say that between 10 years from now, or even 2010, before the America Invention, I'm sorry, I call it America Stop Inventing Act, appeared, I see about between half and a third of the number of applications that I file representing other patents. I hear inventors telling me that it's not worth it anymore to invent. I hear inventors that tell me, I'm going to keep what I know forever as a trade secret, so that I don't care if society learns about it or not. I'll make my money, but I'm going against that concept that patents were created for, which is to improve knowledge. And yeah.
We'll come back in just a second, because you're going to cover a couple of our sections, Shalom.
Mm-hmm.
Good afternoon, I'm Adrian Pelikas. I'm a serial inventor. I'm named on 14 patents, from solar cells to shoes to a number of other high-tech items. I'm a serial entrepreneur. I've helped start up over a dozen companies in San Diego. Last 10 years have been mostly medical devices. I'm also the chairman of the San Diego Inventors Forum, which has over 1,200 active and over 2,500 people involved with that. And so I represent all of them here. I've also been in a lot of my startups funded by Tech Coast Angels and groups that are Uber Angels. And all of us have a very, very deep concern and actually very worried that the entire foundation of our country is about to be destroyed by these new bills.
My name is Gary Lauder. I'm a venture capitalist based in Silicon Valley, my own little firm named Lauder Partners. I'm an inventor of 13 patents, but more importantly, I invest in the companies that are created by others, and often they are companies that rely on patents to be worth investing in. I've seen all sides of this issue. 2 companies that I was chairman of and majority shareholder defended a total of 3 troll lawsuits in the past 2 years. They cost us an average of $100,000 apiece to defend against. But despite seeing that side of things, I can tell you it's an existential threat on the other side. In other words, the inability to properly enforce one's patents is an existential threat. And so I would rather be vulnerable to the annoyance of trolls than to have the right to enforce patents go away. I'm a member of the National Venture Capital Association, which also opposes this legislation. And the key question before us is going to be, do we really want to trade off the preferences of some sectors of our economy, namely those that don't like patents, against those that absolutely rely on and need patents, such as medical devices and energy technologies and so forth. But we can get into that more later.
My name is Nancy Kramer, and I have 3 patents for a personal search engine that will let you search and index anything you want, anytime, anywhere. We are a browser-based software service, and I sort of surveyed the business scene in the search space and decided that if you were ever going to make a business of it, you needed a patent, because at some point in time you would probably need venture capital to at least scale the idea, even if you had a prototype. So that's why I got a patent, or patents.
My name is Steve Lyon. I'm from Minnetonka, Minnesota. The area I create in is packaging. I have a company called Dual Use Packaging. I look at conventional packaging for food products, drugs, and ask myself what else can be done. An example is a pill package line I've developed that's credit card shaped that will fit in your wallet, so you can always have important medicines close by. In some cases, such as aspirin, those sort of medicines can be life-saving. I also, like a lot of us, serve on boards of inventors clubs in our area. I am on the board of the Inventors Network of Minnesota. We believe we're the largest and oldest organization of its kind in Minnesota. We work with a lot of inventors that come into our room, can speak confidentially about their inventions, and we help them get started. We have patent attorneys. It's a wonderful organization, and I'm proud to be a part of it, and it's a big part of what we do, and I can share with you later some of the concerns our members have of this legislation, as well as myself.
Well, as you can see, we have a group of prolific inventors up here that represent a wide group of inventors not in this room as well. If you turn to your packets, we have a couple of documents in here. We have the litigation rates in the patent sector. We have some articles by me. We also have some letters that have been signed by large corporations that oppose the bill, and 144 universities, who are another large group of innovators that oppose what is going on in the Innovation Act. Now, though, I want to turn to the sheet in there that discusses some of the major provisions that affect small innovators. And we're going to start actually with Paul to discuss customer stay.
So the customer stay is intended to stop the lawsuit against somebody who buys this phone and uses it or something like this. But the problem with that is you stay the customer who's a user, they bought it from Walmart. Walmart is now the customer of a distributor. That distributor is the customer of a manufacturer. And the chip inside of here is on a board or a part of it that's created in China, with the actual chip that infringes made in Taiwan. So when you daisy chain all the way up to the end, you do two things. You bring it to the lowest value point, even though that may be the reason you bought the phone in the first place. And two, because the supply chains are so complicated now, you've got joint infringement problems across multiple jurisdictions. What you've done is you've radically increased the cost of litigation and radically increased the risk, because now you've got a really good chance of losing. When you're asserting a patent, if you own a patent and you want to assert it, it can cost you $5 million. There's an equation for that. Cost with risk as a multiplier, and that number has to be lower than whatever damages you get, or you'll never get investors, you'll never get law firms. If you increase the cost and you increase the risk, like that customer joiner, you can't enforce the patent.
Where we have this is the layers of potentially adding costs, and that comes in our next issue as well, which is fee shifting. Steve?
Yes, fee shifting, also known as loser pays, is a common pat answer to frivolous lawsuits, which you hear a lot about. We'll argue that there's many ways to deal with frivolous lawsuits in our current legal system, but one of the ways not to go would be loser pays. You often hear that loser pays is what they do in Europe. If we did loser pays in the United States, it would truly be an experiment. Loser pays in Europe, all their case law, all their precedents, all their judgments have been based on a loser pay system. In the United States, that's just the opposite. Ours is based on not having that. And as I mentioned earlier, it really would be an experiment. And if you wanted to experiment, the innovation industry would be the last place on earth you'd want to do it. And that is because you are pinning small inventors against very large and capitalized companies. There's a movie that's more an anthem for the small entity inventor. It's called Stroke of Genius. It stars Greg Kinnear. It came out about 7 years ago. And it's about an obsessive, paranoid inventor who actually invented the intermittent windshield wiper. And he tried to sell it to Ford. Ford said, no, we can't consider it this time. And then Ford went on to copy it. He represented himself in court over a number of years, and he eventually prevailed. He went through attorneys, and if we had Loser Pays, that movie, which is a great story about how a small inventor prevailed in federal court against the biggest companies out there, if we had Loser Pays, that movie could never be filmed, because he would have been subject to all the legal fees that Ford was pursuing against him. And had he lost, he would have never taken on that risk to go against Ford, because it would have bankrupted him, just in the small chance that he would lose that lawsuit. Inventors by nature are secretive. They want to keep their ideas protective. The fact that it could go to a loser pays system is a real quelling of innovation. It's like, I'm already worried about a large company taking my idea. But now if I have to protect it, and a patent is only as good as the protection you can provide it, if I lose, that would bankrupt me. So it really takes away all viable means to protect your patent in court, to go to loser pays. In my particular case, you know, if I were infringed upon, it would be an extremely large company. And so I would probably not be interested in going to court, which would be unfortunate, because that system is here for us.
This opportunity to go to court is something, and have to pay somebody else's legal fees, is a part of now the cost of when you're talking about intellectual property. Not being able to sue all the way until you go overseas is a part of the equation. We're actually going to go off the list for a second and move to something that is changed in the bill as well, and it's called joinder. But this is another effect, and part of this is that when investors look at intellectual property, or when they look at a company, they look at the intellectual property and it has a value. And so this is another section that changes the value of that intellectual property.
I just wanted to follow up on some of the things that you brought up with respect to the loser pays. Loser pays is how they do it in, for example, in Europe. And there was a report put out by a research organization in Europe a few years ago called "Why the European Patent System Doesn't Work." The organization is called Bruegel. You can look it up. A few years ago, an inventor burned his patent on the steps of Parliament in protest to how their patent system does not work. Among the reasons it doesn't work is loser pays. And in this country, the part of the problem there is that, let me back up. We did have a system which allowed for loser paying in egregious situations. Last year, the Supreme Court, of course known as Octane Fitness, lowered the bar for when the judge can assign the defense costs to the plaintiff. And is now much easier, and now it is happening in, I think, 25% of cases. So there is recently, less than 1 year old, a new rules under which the system is properly functioning. It is creating a disincentive for frivolous lawsuits, and lo and behold, lawsuits are down, particularly ones from NPEs. So also, apropos of the movie you referenced, which is excellent, the name is Flash of Genius.
Sorry.
No problem. I highly recommend it because it really is a great example of what really happens. You know, big company sits there saying, no, that's not possible, you can't do that. Then they go and knock it off. And then requiring the company to sue. This exact situation played out with one of my companies a few years ago. They were both under non-disclosure agreement, and also the technology is patented. We are still having a hard time getting justice. We have what we call a justice system. It's about getting not just getting payback when when it happens, but disincenting bad behavior in the first place. That is a large part of what this is about, and you'll never see that measured in metrics of lawsuits, because it's supposed to prevent them in the first place. It's supposed to get everyone to behave well. And in Europe, by the way, they have a higher rate of rip-offs of small companies. And anyway, I'm a venture capitalist. It's important to me that I think that the risk equation is such that a company is worth taking that risk, and often it is not the case. And joinder is something that would make that even worse. The idea here is that since it is the case that in an egregious case, a non-practicing entity can form a company and use with essentially no assets and use that to sue, and then if there were any liability placed on it, there would be no one to pay it. Therefore, in order to prevent that possibility, this law is giving the ability to look through that organization to whoever owns it, to be able to make the parties that own that entity liable. Well, the problem is that that also means that any venture capitalist or angel investor or whomever that invests in a company that chooses to go try to seek patent enforcement through the courts is now at risk for more than what they invested in the company. This is known as piercing the corporate veil. This is a new thing in American corporate law. It previously was reserved for pollution, Superfund type of violations where people were polluting the environment in extremely harmful ways. But this is, to apply it here would be a strong disincentive to invest in early stage companies. And it is an additional tack that is not necessary. So leave it there.
Yeah, just one thing to that.
Yep.
So when it comes to the joinder, I sold a patent, and they created an entity, and that entity was suing the companies that stole my intellectual property. Half of that money was coming to me, and I was building a software company in all places, Gary, Indiana, one of the worst slums in the country. If joinder is involved, and that company goes out and loses, then I lose my software company. If you're going to invest in my company and I have a patent, and I go out later and sue and lose, you lose your house. If I'm in a field where I don't have a patent, or if I'm a company that doesn't have a patent, but I'm in a field where I could have a patent, and I take your money, I later get a patent, assert it, and lose, you lose your house. Joinder makes it radioactive for patents, for companies with patents, and for companies in technology fields that even if they don't have patents.
If I could add just for a moment, this bill this is the second coming of this bill. The first was when it was labeled 3309 and passed in December of 2013. At that time, in a similar venue as this, I talked a little bit about how this whole notion that non-practicing entities is bad is, I believe, erroneous. And if you're interested in that, my presentation from that is at lauderpartners.com/3309, which was the bill at that time. That's LAUDER partners.com/3309.
And
it's about 10 minutes long.
Thank you, Sean.
Folks, for this country, this is intellectual suicide. This country was built on the premise that you would own the rights to your ideas and you could profit from it. We're dissolving that. And with that's going to go the incentive of every small inventor that wanted to do something and now is afraid to, because he knows he can be challenged in a post-grant review by corporations that have thousands of times more resources than they do. An inventor that starts off sometimes borrows off of their house, as I know I did, to get our patents issued. It was all the money we had. The fact that somebody come back after the patent has been issued and challenge it again, and now as this new ruling is going to say challenge it even further in district courts, is going to annihilate a small investor.
And that actually moves us on to our next section, which is estoppel changes. Can we come back to you in a second, Shalom? We've got several sections that are going to come back.
Just 1 second regarding to that, just so that you'll understand. The level of investment which will expose you to that joinder is 5% or more. It's not 50%, it's 5% or more.
Okay, so the American Invents Act, which passed in 2011, created new easier ways to invalidate patents. Okay, they're referred to as post-grant opposition procedures, PGOs. That includes post-grant review, inter partes review, also referred to as IPR. And these procedures are now invalidating at least 76% of the patents they're directed at. In other words, you sue somebody for patent infringement, they automatically try to put your patent into one of these PGOs because they have a 76% or better chance of wiping it out. There's a lot more on why that is. It's a terrible system that's set up. But here's the thing. There are a lot of reasons. I'm not going to go into this. We don't have the time for it. It's kind of detailed. There are a lot of things about it that cause it to invalidate such a high rate. Because before that, the rates were more like 10 or 15% of patents were invalidated. But here's the thing. This new bill actually expands on that. Instead of holding back and saying, wait a minute, there's something wrong here, the new bill expands on that. Because the way the American Invents Act was written, in a post-grant review, you had to bring all of your information forward, and you couldn't hold something back to use in a later post-grant review. In other words, you could do one good post-grant review, and if you didn't win it, you're out. You can't do another one. Because here's the thing. It cost the party trying to get my patent invalidated 20 grand to start a post-grant review. Cost me hundreds of thousands of dollars, maybe much more, to defend it. As an inventor, we don't have the money. This is a way for, but here's the key though. In the new bill, so this estoppel, where in the past you could only bring one post-grant review, you couldn't hold back data to use in future post-grant reviews. That's called the estoppel. That is being taken out in this new bill, so that you could bring multiple post-grant reviews. In other words, hold back one element and use it for the next post-grant review if you don't win the first one. And it's basically a way to wear out an inventor, deplete him of all his funds, and make him unable to defend his patent.
This is a major change, and it's labeled as a technical correction. We're going to do our last two talking points, and then we have a speaker who's going to join us in a second. Shalom, I need you to keep it brief. But can we have you talk about heightened pleading and discovery changes?
Well, this bill is really unique because it has several aspects that make invention a real crime if you're trying to use it. There are no, if you're trying to file a complaint in court, it has to be plausible. Here, it has to be detailed to a point that you can hardly get to before you can even start people listening to you. You cannot even file the complaint before you come to a level of detail that is extremely hard to do, to know ahead of time. And when you're trying to know, when you're trying to learn what the other side does, there's a common tool. It's called discovery. You ask the court for what documents you believe the other side have that relates to your case, and the court looks at it. They use a reasonable nexus standard, and they allow it or disallow it. Here, the court is practically prevented, other than in exceptional circumstances, from doing it. It limits the number of people you can ask for information, it limits the type of information, it limits the time that this information can be asked, can be requested, and this basically is unique, just like the fee shifting. There is no parallel that I know of in US law. It may be in racketeering laws, and this is the level that they're trying to bring invention to, a crime.
That was brief.
As long as we're on that, if I could just riff for a moment.
Yep.
If a major corporation was trying to lobby our government to, for example, lighten up the pollution laws so that they could pollute a great deal, or if cigarette companies were trying to change the laws to allow them to promote this to minors and take the warnings off the packages, we would consider both such things unethical. In this case, they are lobbying for the elimination of a set of laws that affect lots of other companies in our economy, that will cause less investment in all sorts of things that we as a society need, new medicines, medical devices, etc. People will die at least as much as they would have died in those other two scenarios that I painted. It is equally unethical to destroy our patent system in this country, and that is what is happening. And the companies that are pursuing this, who basically to reduce an expense item that is less than 1% of their overall level of expenses or revenues, for them to do that just because they want to eliminate this small line item of expenses is, in my opinion, completely unethical.
I mentioned a second ago that through the hearings last Congress and this Congress, only one inventor has been called. It's been hard to find a champion on Capitol Hill for that cause, and it's been fun to have our next speaker join us in this fight, Congressman Massey from Kentucky 4. He is a prolific independent inventor. If he didn't have the congressman's schedule, he would be standing here behind the table with everybody as a part of this fight. But just see if you have a couple of words for everybody. I would love it if you came up here, and that'd be great.
For the first 20 years of my career, I was not a politician. I was an inventor, and I've been on all sides of this issue. I was a student inventor at MIT. My bachelor's thesis was an idea that could be commercialized. So the university came in and patented it for me. Now that also made me a licensor later on. I had to come back to the university and license the idea. The idea was good enough that other companies wanted to use the idea, and I filed further patents as an independent inventor away from the university and licensed those patents. So I've been the licensee, the licensor, and I even received a demand letter once. So I've had that pit in my stomach when you open up that registered mail that you had to sign for that says, oh my gosh, is this the beginning of the end of my company? But then after you collect your thoughts, you say, okay, no, this is the way business is done, and they've got either a bad patent or it doesn't apply. But in any case, I've been on all sides of this. Let me just say, amplify a couple points that I already heard here. Great points. Our country was founded on the notion that you own what you create. This was a New Deal. This is original New Deal. But every government before, the government basically had the rights to whatever you created. We had this, it's not in the Bill of Rights, it's not an amendment to the Constitution, this is in our Constitution. And we had inventors that wrote the Constitution. They knew that it was to promote the progress of the useful arts and sciences that patents and trademarks needed to exist, and copyrights. So they knew very well what a lot of congressmen are forgetting today, that strong intellectual property will build a great economy, and it's what we were built on. Another notion that I heard that I try to explain to my fellow congressmen is this bias toward non-practicing entities is a very dangerous idea. Sure, it has some populist appeal. You got a guy over here that just comes up with ideas. He never does anything with them. He doesn't buy the manufacturing facilities to create it. He just likes coming up with ideas. And then you got a guy over here who likes to make stuff, who likes to actually manufacture it. And the notion that one of those is an illegitimate career is wrong. And here's the analogy I use with my colleagues. Imagine if we told all the authors in this country that if you don't own a printing press, then you can't have the rights to your story. We would delegitimize all of the authors in this country to say that non-practicing entities, because that's what you are if you just write stories and you don't buy a printing press, you're a non-practicing entity. We're saying you don't have a legitimate career. Well, that's what this bill that is saying about inventors today, and that's why it's very disturbing to me that we would even consider passing something like this. This is why inventors are up in arms about it. The final thing I want to say is I ask my colleagues, if this Innovation Act is going to promote innovation, why are all the innovators against it? Can you explain that to me? Why are all the universities against it that create ideas? Why are the venture capitalists against it? Part of the answer here is it's the little guy. This is legislation that was created by the big guys to take out the little guys, to pull up the ladder. And we should not be responsible for having our fingerprints on any part of this. No other congressman should vote for this thing, because what you're doing is just enabling the little guy, the big guy at the expense of the little guys, which are the universities, the venture capitalists that bring money to the little guys. You know, at first I thought, oh, if we make it impossible to litigate patents and to enforce your rights, maybe there will be this panacea of 20 years while we go loot, you know, 6 million patents at the patent office and they're all free. And then after that, there will be, you know, the dark ages, because nobody's going to invent if we make it impossible to litigate a patent. But then I realized, you know what, that's not even going to happen. What venture capitalist in his right mind would invest in all of the development that's required to bring a good idea to market and to let people know about it if there weren't some protections there? So even that notion that if you made all patents free tomorrow by, you know, something similar to this bill, that would be of some temporary benefit, that's not even true. So I encourage, if there are any staff here, please tell your members, please don't vote for this bill. It would be bad for our country. Thank you. Oh. Thank
you. The big guy versus the little guy thing is real. And when the big guys infringe on your patents, they don't need to listen to you. If we pass a bill like this, we weaken that right even more, and we have real stories about that. And we went around quickly where people introduced themselves for what they're doing, but we have a story here of currently ongoing infringement on an idea. It's hard to enforce something when somebody tries to steal your idea. So if we could share what you're going through.
Yeah, you know, we've had a product in market, we've had large corporations replicate what we're doing, and we're basically defenseless to stop them. So I know a lot of people say, well, as a company, you can enforce your patent. No, you really can't, not when you're a small company. You want me to expand?
No.
Well, I know with Gary, he is a venture capitalist. That's one of the concerns we have. If a venture capitalist is looking at our company and we have IP, but all these other companies are replicating what we're doing, why is that investor going to invest in us as a small company? Because if there's replication happening, we can't stop it, even though we have a legal right to that property, what we've developed in that idea.
That's the right question, because the reality is that you know, historically, people, when seeking investment, they would say, you know, we've applied, usually they've applied for a patent, don't have it issued. So you have to, as an investor, you have to judge, well, how likely are they to get a patent? How innovative is it? So if you assume, okay, they'll get a patent, then you have a basic assumption of that patent will also be enforceable. But between the America Invents Act and this, if it were to pass, I honestly would not place any material value on patents. Now, will that make all investment in early stage things go away? No. Only those things that require patents. So there are a lot of things that don't require patents. Most internet innovations don't, software doesn't, so there is a segment of the venture capital industry which only invests in internet and software things that are saying, oh, this bill's great, because they're only on the receiving end of patent lawsuits and they never a plaintiff. But unfortunately, we would lose something that is incredibly valuable in our society, because the vast majority of innovation types actually are hard to develop and easy to knock off, and that's where you really need patents. And so medical devices I mentioned before, but the Internet of Things, there's a whole new area that I think is going to be huge in optics. Optics are an area where patents are critical. Semiconductors, it has been, and so point is, there's all sorts of new stuff, new fields that have yet to even be, that we don't even know about yet because they haven't been invented, many of which will need patents. And so we are trading off what has made this economy unique in the world. There's only one other economy that has more venture capital invested per capita than America. I mean, the next closest, Europe has 1/10 as much. But Israel actually has more venture capital invested per capita. But they don't rely on their own patent system, they rely on ours. So in fact, it is arguably our patent system that has made this as what it has been, and we're about to flush that.
You know, some of the large tech companies today, just think back a few years ago, they started, many of them, with a single patent in a garage. And those companies would not get off the ground today with this, if this bill were passed. And it's significant because we've seen this happen in other industries when big business conspires with big government, what the results are. We saw it in the 50s when General Motors really literally changed the landscape of transportation in this country. We didn't have public transportation, we did not have safety standards, we did not have oil and fuel consumption standards, and 30 years later we're bailing the companies out. If you do not have the continual process of new ideas coming through and filtering up, if you take them out of the equation, then these tech companies today, 20 or 30 years with no competition, will myopically look inward, and you'll see the results of this.
Steve, you wanted to jump in?
Yes, just wanted to put an explanation point on the Congressman's comments, which were outstanding. And that, we all know the Patent Office was created in the U.S. Constitution. That predates the Bill of Rights. But to this day, only an individual can be granted a U.S. patent. And I think we ask you to give the inventor the benefit of the doubt. We are named inventors on patents. That's what the Patent Office recognizes. But it does seem like the playing field has changed in the last 5 years where the preferences are going to the larger corporations. So please consider that as you make your decisions.
We're going to open it up to questions here in just 1 second. I want Louis to kind of sum up for us and kind of walk us through.
Sure. First off, we appreciate you listening to what we have to say. We're independent inventors. We're not well organized. We're certainly not well funded. But what we lack in funding and organization, we make up for in passion. We believe in intellectual property, and that's our incentive to go out and invent. So we come up with those great ideas, and sometimes we're entrepreneurs and create businesses around it, and in other cases, we find the right companies to partner those ideas with because they're good at manufacturing, they're good at distribution. I produce a TV show for PBS called Everyday Edisons, and each season we travel around the country meeting independent inventors. Last season, 35,000 independent inventors brought their ideas to us, not because they wanted to start a company, but they wanted to see their dreams come true. They wanted to see their idea end up on a store shelf. None of them wanted to open up a factory, none of them wanted to manufacture something, but they believed that if they had an intellectual property right to their idea, that idea could be licensed and they can receive royalties on those ideas, and ultimately those products would get to market. So we really hope that you understand that this bill does not take into concern the independent inventor. We are the collateral damage here. We are the unintended consequences of big businesses who are trying to lower their costs of doing business at all expense to the independent inventors. So please do not move forward with this bill.
All right, I saw a first question.
My name is Carrie Deborah. I actually founded the Center for Corporate Integrity with me, but because of my world of arts and photography being decimated, where inventing is going to. I actually owned one a soft toy, so nothing I did was based on someone else's intellectual property. But we have to put on our manpens here. You have to state that Google and the other companies are the ones that have been setting these bills in rule and in play. I wrote about this last year. My recommendation was idiot-proof. Publish the patents that exist on a product on the outside of a package. It has to be the liability of the manufacturer to remove the liability from the end user. But regarding being secretive, it doesn't work in the world of patents. Your patent is published. A mentor taught me the minute our patents are published, it's bring it on to people to do better. And simply, the last note is that no lawsuit is frivolous if you own the property. Why is it that if we as property owners challenge someone stealing from us, that we are called trolls? So we're on the same page. Look towards the arts industry, look towards the music industry. It's the same problem, one model, different wheels.
What we're worried about in terms of frivolous is that a big corporation makes a frivolous lawsuit against one of us because they've got all the wherewithal to defend it. We don't. That's the frivolous side.
We have to put steps in the way, possibly a way to expose their claim first before the matter move forward, possibly mediation, but not mediation with an eye towards litigation.
We're not going to get here.
You bring up copyright. Copyright is extremely well protected. protected 70 years after the death of the artist. And you make a very good point about it is the property, whether it's frivolous or not, it is the property of the inventors. And when you compare to copyright law, it's exponentially weaker than what they have. I owned a furniture store once, and a man came into my furniture store and he said, you're playing the local radio station. I said, yeah, thanks for telling me that. $10,000 fine. I said, huh? He went on to say, another song's coming on. And he said, but trust me, I can help you with this. I represent ASCAP, and we will offer you a subscription. I said, well, I'm from Chicago. We don't call it a subscription there. and all I tell you that story is that this is what intellectual property is. It's supposed to be protected. It's very well protected in the copyright laws. And it's not as well protected, and it is being challenged with us inventors. We feel we should have that same deference that the copyright people have, even though our terms are much shorter, 20 years. And a lot of times it takes a good 5 to get it issued. So please consider this. That's just what the nature of intellectual property is, just like the copyright people do. We feel we'd like it to be the same way, and give even the troll the benefit of the doubt that, hey, there might be some there that they do have property that could be protected, and don't change all the laws that we live by every day as a result.
It's an important point. Life plus 70 in an internet world means nothing. You post anything online, the minute your patents are released at 2 a.m. in America, they're gone. So in an internet world, we've lost all of our rights. What good is a piece of paper when a lawyer won't take your case?
She's right. Google Images, that's all I'll say. If you use it, and I'm sure you do, you'll know what I mean. They deep link into your images. I have a photo site. They even take your bandwidth.
One of the things that we see here is that this legislation, the policies, the suggestions move into every piece of the law, every piece of the invention process. Is there something, I know that I've heard a couple of you mention a couple of different ideas, but is there something that would help out the system?
There are a number of things. I'm not sure this is the right venue, because typically the way the legislative process would work is the good ideas would then be subsumed into the bad bill to make the bill dilute the badness of it, but all the badness would remain. It just would have a couple of good ideas. And so honestly, I don't think this is the right venue to try to introduce improvements.
What about that Strong Patent Act thing?
That bill is generally recognized as safe.
Yep.
The biggest problem is the cost of litigation. What you've heard from is the companies, they're complaining about paying $5 million for patent litigation. We as inventors, we'd have to pay $5 million to enforce our patents, which we can't afford. That is the problem, it's the cost. The solution, the traditional solution has been licensing. That have a negotiation between the company and the inventor and work out a license. To have a license program work, you need certainty that your patent is valid. The patent office has gone through an examination process. They've given you a patent. You've got the stamp of a government agency saying you own that idea. Having the agency then be able to reverse itself 83% of the time means there's no more certainty. It means companies have no reason to negotiate with you because they figure they can invalidate your patent before they pay your license. The system has moved away from certainty, and as a result, there's no more licensing. The licensing market has dried up.
Paul, you have something?
So I don't know how many of you saw Chairman Goodlott's video as his opening statement 2 hearings ago, but it's a string of people who have been sued by patent trolls. And if you take the emotion out and just listen to what they're saying the cost is too high. So they've been sued, and the one guy, the radar company in New Mexico or something, was sued by a toy company. He didn't feel he infringed, but because it was so expensive for him to defend that case, he paid the troll. The cost is too high there. The cost is too high on our side. The little guys, the cost is too high. This bill raises cost, raises risk. We're going the wrong way. The problem we have is a very weak patent, and it's stolen. If you have a fiduciary responsibility in your company to steal patents, because there's no injunctions and there's no treble damages. You simply make the decision that's best for your shareholders and screw the inventors. Then we have to sue, it's $5 million. If those are strengthened, if you strengthen the patent rights, give us our injunctions, reduce the cost of litigation, then it'll be less likely that they're stolen. And then we will create companies, those companies get acquired, and the customer in the end buys patented, protected stuff.
Warren? Exactly. So there is one other issue too, and I'm not sure how many are aware of, probably are, but there's a significant amount of money that goes into the patent office every year, paid by inventors in the filing fees and so forth, and there's something about $100 million in surplus that comes out. It's not a tax, it's money that we as inventors pay. That money is taken out of the patent office and put elsewhere. That money should stay in the patent office. If the argument is you want better quality patents, better reviews and better patents coming out that are stronger so they don't have to go through this post-grant review process, then keep the money in, hire more examiners, do better training, and make the patents that come out better.
And the reason I wanted to bring this up was just that if we have a bunch of hearings and we don't bring in the innovators, as I mentioned and Congressman Massey mentioned, and we have a bunch of hearings and a bunch of bills that don't fully fund the USPTO, calling it an Innovation Act makes it a little bit harder. Shalom?
I would like also to point out one interesting item. Take a look at this bill. In it, there is one paragraph that talks about the benefit of inventors. And it's a study that the USPTO is supposed to create a study regarding the effects of small inventors, specifically disadvantaged women-owned businesses, things like that. What is the effect on their ability to enforce patents? Every single other thing in this thing is directed against one group, the inventors, the small inventors. The large inventors, they don't care. They can afford the litigation. The large trolls will not be affected by it, because if they are directing the true trolls, and I want to differentiate between people who try to legitimately assert patents in the area that they should be asserted. Those are different, but on those that are real trolls that will send to every one of you a letter trying to pick up $1,000 or less, those will not be deterred by anything here for a very simple reason. What is going to be your loss if you won in a trial, if you went to trial and won? They have 100,000 of them. They'll pick up $100,000 from each one of them, and they lose 3 of them. Each one of you is $30,000. Big deal. It will not do what it meant to do, but it will cause a huge amount of damage to all the concept of innovation. Think about all of the things that were invented by small inventors.
So you mentioned that the bill calls for a study. The America's Invents Act called for a study to see by the Small Business Administration to see what the effect on small businesses would be of first to file. But they never allocated the monies for the Small Business Administration to do this study. And so I offered to donate the money for them to do the study. They said they couldn't take it. I offered to hold a bake sale for them. They couldn't do that either. So the promise to do a study is just such a cynical, underhanded, it's an insult to everyone's intelligence. And again, they should be ashamed.
All right, do we have any questions? Yes.
Does the issue of fast track affect patents?
Fast track? I didn't hear the question.
Fast track. Is that the $4,000 you pay $4,000 to get it? Well, the problem is...
Are you talking about the trade law fast track? Oh. You're talking about the trade law changes, yes. The TPP, yeah, there are international implications to all of this because, again, you have to defend and the investor has to pay. And yes, the short answer is yes.
For those of y'all that have recently participated in patent litigation, how much, say it costs you $5 million to participate in a litigation suit, how much of that is not attorney's fees, so court costs and expenses and things like that, because the bill is not providing for fee shifting of attorney's fees. So how much, I'm trying to figure out what the average number for the actual fees and expenses aside from attorney's fees.
I'll take that. It's about $3.5 million in attorney's fees, about $1 million and a half in expenses. That's mostly expert witnesses. And now we've just added about $1 million in defending IPRs.
Okay. So out of the $5 million, about half is going to fees and expenses outside of attorney's fees?
Right, about $2 million, $2.5 million for expenses and $3.5 probably for attorney's fees.
But on top of that, with joinder, well, actually this loser pays in general. You basically, if you don't prevail in your lawsuit where you're trying to defend your patent, you end up have to build in another 500 grand in simply defending that your patent was reasonable, right? Because you're guilty until proven innocent. So you're talking about another area of increased cost to a person, to the whole system, basically, but also, of course, to the inventor who's trying to defend his patent.
And the investor.
Here, 1 second. In the benefit of everybody's time, we're going to run through and we're going to just quick closing statements from each of you. You all came in from across the country. I want to give everybody a second to make just kind of the last statement and the last pitch. We can start with you, Shalom.
Okay, just to add to that last question, the bill also adds a discovery cost of the other side, which is again unique in most cases. Basically, as I said, I see inventors come to me with ideas, and a lot of them now tell me, we are not going to do it. Myself, I stopped developing a project regarding efficiency in aircraft propulsion simply because I don't think that I'm going to see any money out of it because of the AIA and this legislation, if it ever happens to pass. And I think that everybody has to ask himself, we talked about windshield wipers, both the windshield wiper itself and the intermittent windshield wipers that you use every day were developed by individual inventors. Lasers actually were developed initially by individual inventors. There are so many things that was developed by individual inventors, and you do have to ask yourself if you prefer the endless reliability of the software provided by certain operating system companies versus the inventions that you work every day. Because when you kick out the small inventors out of the innovation business, this is what you'll be left with. The slow, purposefully slow development of large corporations of new technology versus the advancement that we have achieved in the last several hundred years because of individual inventors. Those bills, the AIA and HR 9, attempt at killing small inventors, kicking them out of the innovation business. Ask yourself if it's a good idea.
Thank you, Sean.
Please stop this bill. Small innovators need to be given all the help they can get, not the hindrances, barriers, fears, and worries that they're now being faced. Our patent system was a cornerstone of what made this country great. If we dissolve that, there goes our country. It is that powerful, it is that strong. Innovation made this country a leader in the world. Why should we change the best system in the world just to dummy it down to what the rest of the world does, which doesn't work and nobody likes? Thank you.
I agree with all that. I think it's worth noting a couple of things here. Many of the Republicans feel that this is a form of tort reform, and they like tort reform, so let's do it. It does need more thought than that, because the fact is that there are egregious aspects of our tort system, but this, we hear more about the injustices of some troll lawsuits than we hear about the injustices of people's ideas and patented products and so forth being stolen. It happens a great deal more than is realized. It doesn't get written about. People, the press writes about successes. It doesn't often write about those types of failures, and so. But it's a very real problem, and it will be made worse by a bill such as this. The part of why this is happening, this bill has so much momentum, is that the people who are funding it, the large companies that that are net defendants and want to reduce their expenses. They are parading the shopkeepers who receive these letters and so forth. They need a boogeyman, and patent trolls are that boogeyman. But patent trolls actually, it's a pejorative term for entities that perform a valuable role in our society. Edison would be deemed a patent troll under this definition, and as would be most universities and research labs. So, also the statistics that you hear about it costing our economy $29 billion per year, these come from studies that were probably paid for by these companies that have been completely discredited. If you Google the term, the primary authors of these are a pair of professors named Besson and Moorer. If you Google their names along with the word discredit, you can find the studies that completely debunk it. However, despite that fact, it is still published in the White House's analysis that published a year or two ago on PAEs, and it was cited by our as recently as last night by Chairman Issa at the hearing, and so unfortunately there's a lot of misinformation about this that make it appear to be a worse problem than it truly is.
Thank you, Gary.
Well, what I think is if this bill passes, it'll kind of be the end of the venture-backed company in the United States, the venture-backed startup, which is, I mean, there are just so many of them that have changed our world, including Google and Facebook and Twitter, and that they will just not happen anymore because VCs want a wide moat, and at the beginning all people have is a patent. And if they can't enforce that patent, and the VC might actually get sued if they try because they're piercing the corporate veil, there's really nothing anybody can do. And the minute your idea gets traction, a lot of people like it. What's to keep a big company from writing software just like yours? I'm more in the software patent world, so that's how I look at it. And that is like a really big problem. And getting back to individual inventors, I'm sure all of us have used copying machines, you know, the Xerox machine. Well, do you know that was created by an individual inventor? And that inventor licensed it to Xerox, who built a company around it, his IP. He had a prototype, but they built it, and as they say, the rest is history. It has literally changed the world of the office. But that's an individual inventor. But they played, you know, they did the right thing. They licensed it from him, and the world got to benefit from his invention, and them too. I mean, they got to be a big company.
Paying for an invention works. Steve?
I'd say beware of political strategies. We all know the work of Frank Lutz. He famously came up with the term death tax. It changed the whole estate tax debate to a level that people never expected. First heard about this issue with the word patent troll. It's a similar strategy. And what we've talked about today has very little to do with the patent troll. And that's what I ask you to, as you look at this, is this really about the patent troll? Or are there other interests at work that really do and will have a dangerous effect on small innovation?
Randy?
There's this term, the American dream. And you think, if you really look at it, we kind of take it for granted. But other countries don't have their dream. But America does, and they see, the rest of the world knows about the American dream. A key reason that there is such a thing as the American dream is that we have historically had a patent system that was better than what the rest of the world had. That was better for the individual who creates something new and valuable, that allows them to protect it and build something with it, or license it to someone else who can build something from it. But this is a key part of America and what has made us what we are, and this bill will destroy it.
As a startup and operating company, we feel that HR 9 will actually lead to IP inequality. And by that, I mean it's going to make IP more valuable for larger corporations because they have the financial resources to stop infringement. But for smaller companies like us, it increases our cost to try to stop infringement. So just hope it doesn't pass.
Paul?
So I think one of the big problems is that year after year, we keep talking about patent reform, and every time we put a bill out there like this one, it shakes the market. I can tell you right now, nobody's investing in patents. There's very little investment in patents going on right now. You're not firing up companies and stuff like that because nobody knows if this incredibly stupid bill is going to be passed. And I just think that it's time to end it and go the other way. We're going the wrong way.
The ink hasn't even dried on AIA, which took 7 or 8 years of considerable negotiation. All parties brought to the table to even have that move forward, which was the most significant change in patent law in 150 years. This is right on its heels. We haven't even let the process play out at all. As was said before, a lot of unsubstantiated facts have been debunked. When you read press releases, it's almost annoying to us to see how much fictitious in it. I'd like to also reiterate that the second building built in Washington, D.C. after the White House was the U.S. Patent Office. The first commissioner of the Patent Office was Thomas Jefferson. Abraham Lincoln said it was one of the 3 wonders of the American society. It's in our DNA, it's in our veins. We need to keep it. One of the largest housewares company in the country that I run the Open Innovation Program for was started on a patent. It was a patent for the tabletop knife block, okay? And now it's a $1 billion company today that employs 1,500 people. You take this away for the purposes, the myopic purposes of a few large business entities that are already multi-billionaires already, and you're going to disrupt everything. I want to have one last pitch. There's a movie coming out on May 19th called Tomorrowland. It stars George Clooney, big budget film. Actually, the UIA is doing something big at the hardware show where we're helping to launch a little part of that movie. It's going to be a wonderful world where kids can go anywhere and invent anything they want. And we hope that just brings an air of optimism back to the inventor community because we've been on the other end of nonsense for too many years, and it's time to turn it around.
Richard? Let's look at the facts. Back 3 years ago, before AIA, the average patent was sold for about $100,000. It cost an inventor $20,000 to get that patent on average. In the last year, the average price of a patent is going for $30,000 to $30,000. It still costs the inventor $20,000. There's no way to make a living inventing post-AIA, and this bill will drive that $30,000 much lower than it is.
I mean, let's face it, there's some bad actors in our industry. We recognize it. They're exhibiting bad behavior. But this bill doesn't solve that problem. It destroys the entire ecosystem. It'd be like having a few weeds in your lawn and deciding that you're going to kill your entire lawn and all your neighbor's lawn just to get at those few weeds. What Congress really needs to focus on is a surgical approach to prevent the bad behavior, to make it very difficult for companies to go after and sue, with no grounds, but to completely destroy the patent system over the actions of a few bad actors is just unconscionable.
Well, I want to thank you all for coming. This is an important issue. We're going to be around afterwards. Again, they came in from across the country just for today. We're doing some meetings later today, but we're more than happy to answer any questions. And please look into this bill more. Thanks again for coming.